Hello, everyone. Good morning, good afternoon, good evening, wherever you're tuning in from. I hope you can all hear me properly. Please just indicate by giving a reaction. Can everyone hear me properly? Thank you. Thank you. Okay. All right. So I just want to give a few more minutes for people who are joining in, the late joiners, to join in quickly. So maybe 2 minutes, and then we can just kick start. Okay, so I think we'll just go ahead now and people will join us as they come in. So good morning again or good afternoon, wherever you're tuning in from. My name is Jennifer, and I'm pleased to welcome you to this roundtable discussion today. And this discussion is being organized by Privalex Advisory. So Privalex Advisory is a data protection and compliance organization. And so we offer data protection as a service, which means you can hire us as your DPO for your organization to handle your data protection compliance needs. We also offer data protection trainings for professionals and for organizations as well. And speaking of that, we have a bootcamp training coming up in March. So if you would like to join us to get more knowledge, to become a privacy champion, feel free to register, send us an email, and we would contact you with more information. So we have the opportunity for those who are resident in the UK and also for those who are resident in Nigeria as well. So feel free to take advantage of this opportunity and let us help you gain more data protection knowledge. Okay. So we have some great speakers lined up to be part of this event. And I'm just going to introduce all of them now. So first of all, let's start with Tayo. We have Tayo. You can see him on the screen. Feel free to wave so that people know who you are. So Temi Tayo is an attorney and he's an AI governance professional. So he's bringing today his experience from working in the healthcare sector in Amsterdam and also being part of the Nigerian diplomatic missions in Brussels. So he will be sharing with us all that he knows today. Next, we have Christina. She's smiling. Feel free to wave so that people know who you are. Christina is a GRC professional. She is the Information Management Director, and she also founded the Data Privacy Black Professionals Network in the UK. So if you're in the UK and you are yet to be part of the Privacy Professionals group, you should definitely speak to Christina and be part of it. Amazing things happening there. Up next, we have Philip. So we have Philip. He's the Chief Privacy Officer of DPO 360 Africa. And he's currently joining us all the way from Kenya. That is where he's bringing his experiences from. He is currently part of the Data Privacy and Governance Society in Kenya, making sure that the policies that are being produced are to the benefit of those who live in Kenya. So if you have issues in Kenya, feel free to reach out to Philip as well. We also have, let's see if he's here and if he's already joined us. I'm going to introduce him anyway, unless he's not here yet. We also have Wenga. He is the founder of Preplug. So he's founded an app which can help you access your privacy laws. So wherever country you're in, you can access the privacy laws and the requirements so that it's easy for you to know what you can comply with or what you should be complying with. So feel free to check out the application. You can check it out from the Apple Store or Play Store. And he's also part and bringing his experience. Can you hear me properly? There's someone whose mic is unmuted or trying to speak. I don't know who that is. But if I will ask you to please mute your mic, unless I have called you up, please, so that we can hear each other properly. So Wenger is also bringing his experience from his consultancy career at PwC and EY as well. So we'll have a lot of things to share with us today. And then we also have Ilya. I don't know if he's on the call yet, but hopefully he'll be joining us soon. Yes. We have Ilya. He's a privacy and perfect, wonderful. If you can turn on your camera so that people can see you, you can wave as well. So he's joining us all the way from Russia. He's bringing his experiences from the healthcare sector. So he's very passionate about international data transfers and restructuring of privacy issues. So we hope to learn a lot from him today. And our final speaker, Victoria, unfortunately is avoidably or unavoidably absent. So she's not able to join us today, but she sends her apologies and hopefully we'll be able to have her on the session maybe in the future. Okay. So that's all of our speakers here introduced. Just a few ground rules before we continue. Please, if you're not speaking, just ensure that your mic is muted. And for our speakers, please, of course, be on camera so that people can see you, so that they can hear you and be able to interact with you. And then for the rest of the audience, please, if you have questions, we have a Q&A section. So as we go along, if we have any questions, please feel free to put them down and we would get back to it at the end of the conversation. And hopefully our speakers will be able to address them. And then finally, just enjoy the session, really. You know, if you have questions, if you have comments, you know, feel free to react. If something is funny, feel free to laugh, you know. It's meant to be engaging and it's meant to be interactive. So please be part of the session and just enjoy it. Okay, so without further ado, let's just introduce the topic we're talking about today. And the topic is addressing the power asymmetry between data subjects and data controllers. Now, the term itself, power asymmetry, it sounds like a very big term, but what it simply means is that there are two parties involved in a situation, but then one of the parties has much control. They have more influence and they make decisions. And they have the ability to make more decisions than the other party in the situation. So for this context, we're talking about data controllers. So data controllers are your big organizations. You know, they're organizations that collect your data. So we have your big tech companies, we've got our government, we've got businesses. So they collect and store our personal information and they use it, you know, to do whatever it is that they may have said that they want to do with it. And then on the other side, we have the data subjects, which is regular people like you and me. So we are the ones who have given these organizations our data. And so when we talk about the power imbalance, we are saying that data controllers, they have more power, they have more control, they have more influence in the data that we give to them or the data that we make available to them. And we, the data subject, we have little say in how our data is handled. We don't have a lot of say in what they do with our information. In fact, we don't even know every single thing that they do with our information unless they actually tell us. So that is the power imbalance we're talking about. And the reason that it exists is because we live in a very digital world now. And so if you want to access services, if you want to have, you know, I don't know, have a social media account, if you want to access your hospital or your banking, you are required to part with your data. It's more like you have to give your data in order to get a service. So you really don't have a choice per se, unless you don't want to have that service. So that's the world we're living in now. And so we have very limited choices that if you really want to have a service, you're going to have to give up your data. And so why this topic is important to us now and for us to talk about it is because we have these companies who collect our information, which is amazing. But the thing sometimes we are unaware about is that they influence the decisions we make. So because they have all of this data about us, they are able to do, for example, targeted advertisements. You know, you might not have been considering buying something, but because the company has your data and they know the sort of things you like, they can then suggest those things to you, and you find yourself considering buying their products. And it's as a result of the information we've made available to them. So this is one example. And of course, in politics, for example, I mean, on social media, if you all follow the elections, you can see the amount of information that went around, supporting whatever political parties that there is. And again, it's all just based on the information that they can get from you online. So if they feel you are more able to be susceptible to buy their ideas, then they would come to you, and that's just how it works. So all of these things are things we can bear in mind. And then, of course, the fact that when we give our information out to these organizations, it's usually difficult to actually delete it. And it's usually difficult to be really sure that they've cleared it off their systems, so you don't really have that much control the moment you give that information to controllers, even though, of course, we have the regulations trying to limit what these people can actually do with your information. So that's what we're going to be talking about today. And our speakers will be able to help us to shed more light on this topic. So without further ado, we're going to get into the conversation. And the first thing we will just talk about now is to just look into the sources of the power imbalance between our data subjects and our controllers. So we're asking, so what really causes, this data imbalance that we've seen? So I'll start with Tayo. Tayo, feel free to give us your ideas. What do you think is the reason why an imbalance exists between controllers and data subjects? You're muted.
Thank you very much, Jennifer, for the very comprehensive introduction. It feels like you have even covered the question in the introduction itself. But it's a pleasure to be here. Thank you, Privalex, also for the invitation to speak to this very important topic. So I'll just jump right into it, right? I think, like you rightly mentioned, we can all agree that indeed there is an imbalance of power between data controllers and data subjects. And there are a couple of reasons, in my opinion, there are a couple of reasons for that. I think prominently, information asymmetry would be the first thing that jumps out. Information is asymmetry in the sense that data controllers usually have more information on what is happening than I do. For example, if I use Twitter knows what is happening. They have a more comprehensive understanding of the entire chain of processing than I do. I don't have as much information as they do. I have limited information, and because of that, there is no real balance. I cannot make informed decisions in that regard. Another source would be transparency, right? So when we look at the privacy notices of these big organizations, they're usually very complex. Nobody has the time to go through these privacy notices. So they are not that transparent in the sense that they don't fully capture what they do. To a very large extent, a lot of their processing activities are not contained in these privacy notices because indeed they are only space. They do so much, right? Another source for me would be, I think, the complexity of data processing itself, right? An organization like maybe Twitter, let's say Twitter or Facebook, they do so much, right? It would be almost impossible for them to outline everything that they do in privacy notices. It's very complex. And even if they do, if I read it, I wouldn't understand as an average user, right? So due to that complexity, it's very difficult for me to, give any kind of, or make any kind of informed decision, right? So by virtue of that, they already stand in a more, I would say, more advantaged position than I stand. So yeah, a few more sources. I would say also resources is another thing, right? I don't have as much money as they do. I don't have as much. I cannot engage lawyers to come and, explain what Twitter is doing with my data, what Facebook is doing with my data, right? So if you look at all of these things, you can rightfully point to them as, I would say, sources of power imbalance.
Thank you. That is so true. And I mean, and I have to say, especially the part of transparency, I also, for one, don't believe that we know every single thing that is happening with our information behind the scene. We just know that we don't know, but we just accept what they give us anyway, and it's just what it is until someone can actually come out and say, oh, this is not happening correctly, or this is wrong, that means we want more, shall I say, I don't know, strong-willed DPOs, if I would say, because they're the only ones who are internal that can actually stand up to the big boys and say, we need to get this right. So if we don't have good DPOs working for the big guys, then we're in trouble. That's what it
It
means. It really
helps,
means
but
we're in
also if
trouble.
you look at the dynamics of relationships too, right? By default, you can have an imbalance of power. Look at the employment context, for example, right? There's a presumption that my employer stands in a better position than I do. If they propose anything to me, I won't have any choice but to say yes to it because or there's a presumed or a rebuttable presumption of an imbalance of power between us. So by virtue of that relationship, by default, there is already a power imbalance, and that's why in the employment context, the industry recommendation is that we do not use consent as a legal basis for many of the processing activities in the employment context. So yeah, that's also another very strong point, a strong source.
Thank you. Thank you for shedding light on that. So, Ilya, I see your hand has been up for a bit, so I'm sure you want to get into this. So let me just ask you a question straight on and then you can answer it. So we've been talking about controllers having this, this power and this
Yeah.
advantage. So what sort of financial benefits, if we call it that, can they gain as a result of this advantage that they have?
Thank you for your chance. First of all, I'd like to point out about the opinion of the EDPB as of April of 2024, because it's really useful example of how regulatory approach must be, as per my opinion. Because first of all, this opinion refers to three elements of free choice. Because as per my opinion, free choice is the beacon how we can achieve symmetry between imbalance between interests of data subject and data controller. There are a rule of three no detriment. First of all, no detriment. What means no detriment? If you cause no detriment to data subject, it means financial consequence or material consequence or any other. Means that this consent is free, or any other will of data subject to process data is free. The second is no compulsion or pressure on data subject. You know that many e-commerce, any other digital businesses often use tricks or many other manipulation tools so as to make data subject to accept unacceptable terms of data processing. And third, no multi-purpose consent, which means no multi-purpose. One consent, one purpose. One processing operation means one purpose. In summary, three elements: no compulsion, second, no detriment, it means no damage to data subject, including financial consequence, and third, no multi-purpose, concrete purpose of data processing. And answering your question, it's my pleasure to answer this question. I'd like to point out that financially, any company, regardless of any sectors, must focus on respect for users, for clients. Yes, because when you provide respect with the rights of your users, you create conditions where then where they can express confidence in relations regarding the data they communicate to you as a businessman, as a business. Yeah. So and any consumer confidence may have a financial effects on your financial statements. It enhance your revenues annually, monthly, quarterly. So I don't know how to measure up this success, but many consulting firms like Big Four or Big Three, often publish reports where they concluded that companies that really compliant with privacy frameworks like GDPR, like CCPA, or any other, for example, NIST framework, they get ahead in the market than the companies that don't respect the users. So thank you, Sarah. Thank you very much.
Thank you. Thank you. And I think that should be the case, because if the enforcers, like the ICO, for example, if they're doing their job, then yes, those who do not adhere to the legislation should be made to pay for it. And therefore, they should not be financially gaining from it. But then in situations, for example, in Africa, where we don't have a lot of enforcement and, people get away with these things, you can see that their bottom line, instead of decreasing, is actually increasing. So they're making more money off of you and they're not made to pay for it. So just moving on from that, in terms of marginalized population, because we do have vulnerable people who do not understand, what you're talking about in terms of data protection, who doesn't even care, or might not even be able to understand because of the illiteracy based on digital skills. Christina, I'm just wondering, this question is for you. How will this imbalance really affect these kind of communities? People who don't have access to the information we have, and people who are not as knowledgeable as we are in terms of data protection. So how will this imbalance really affect them as people?
Yeah, thanks, Jennifer. And thank you for the opportunity to be here today. I think this is a complex question, because when we talk about data imbalance and then marginalized groups, in the AI world, we're talking about access to digital technology, we're talking about data bias, and then we're talking about what all of that means in the AI world in terms of the amplification of bias and inequality. I mean, I'm not sure what the answer is, but if I can share my own view about what seems to be happening and what the future kind of looks like, I question whether we will ever get to a stage of global symmetry, global power symmetry. I question whether we will ever get to a stage of true a transparency, if you like, from the data controllers and the organizations. Very often they don't know, how these data models work. And even if they do know, they don't care about the harm. And in terms of the enforcement, I mean, you talked about Africa and a lack of enforcement. I would say ditto in the UK. I'm based in the UK. We have the ICO, the Information Commissioner's Office, who's our UK data protection regulator, and there are, lots of views expressed about the ICO not really using their enforcement teeth to, punish those who are, opaque with their data processing. So I think the best we can do, I'm not going to pretend as I've got all the answers, but going back to your question around, power imbalance and marginalized groups, individual awareness, and us as individuals, data subjects, holding all organizations to account will definitely help. I think it's part of the ecosystem of the whole accountability framework. We can't just rely on DPOs, data protection officers, and regulators alone. The accountability framework, in terms of the pressure to hold data controllers to account, includes us as individual data subjects, through our awareness, exercising our rights, and speaking up when we want more transparency and when we see the data abuse.
Thank you. Thank you. That is very spot on, actually, because I'm thinking we have to have some level of advocacy happening. We have to have some level of, I don't know, trainings going on for people to be more aware. Yes, in the UK, people are more aware of their data protection rights and, what they can get, but it's not the same in every part of the world. And so I think it's easier to exploit the areas where, well, no one is really batting an eye, whatever you do here. So people would probably take their businesses there since they feel like there will be no actions, leveled against them if they did something terribly wrong. And so my next question really to Philip would be in terms of advocacy, in terms of having people speak up. I mean, do you think that we can have NGOs, do you think we can have people who are passionate about data protection probably doing more, just so that we can mitigate some of the risk that comes with these imbalances?
Thank you. Thank you very much for your question. I think being the last one to answer a question is one of the hardest things, because the rest I've gotten easier questions and I've gotten the harder one. Anyway, I joke. So I think NGOs especially have played a very big role. And I'll just give the situation example in Kenya, where we have Amnesty International and the Open Institute really leading that charge in terms of just coming up with programs that are geared or that are shaped towards advocacy for stronger data protection laws. We've also seen these advocacy groups be the ones that go to the streets, be the ones that hold town halls and just try to shape the way policy in this space of data protection looks like. And therefore, their role cannot be undermined. You look at the NGOs that are in this are typically what we call the human rights-based NGOs. And you'll see they've tried now to pivot from that and now more clearly focus on the space of data protection. So just to answer your question very concisely, I think NGOs, CSOs, and all organizations in that space really play a major role in shaping how data protection is taken up by especially African countries. And you look at their role in also assisting in implementation of data protection laws. We talk about data protection from a global perspective, and I reckon that in the UK and the EU, a bit more advanced, the GDPR coming into place in 2018. In Africa, many jurisdictions are just picking this up, and they're picking it up from a point of view of coping from the GDPR. And so you find that there are issues to do with capacity, one. Number two, to do with budgets. And so NGOs also come in to just fill that gap and say that we're able to take 1, 2, 3 off your plates in terms of capacity building. We'll come up with programs that will be geared towards educating the population or even enhancing capacity of the data protection authorities. Thank you.
So
Thank
very
you.
quick addition to that, right? I would say that one of the biggest advocates or stakeholders when it comes to operationalizing data protection laws would be NGOs. I don't know if you're familiar with NOYB, none of your business. I work with them. They are
I was literally
singularly,
about to ask for examples.
yes,
So we
they are
know.
singularly, I would say, they are the forefront of operationalizing the EU International Data Transfer Framework. Before, what we had was the law, right? But then they were responsible for challenging, Safe Harbor, Privacy Shield, and very recently the Data Protection Framework, the TPF, that regulates the transfer of data between the EU and the US. They will challenge that. That is already in court, and in the next couple of years, it may be scrapped, just like the previous two. But they've done quite solid work in that regard. We have clarity, primarily because of the work they're doing. But that's even EU-based. I mean, if we come back to, let's say, Nigeria, there are also very local, I would say, NGOs that are doing amazing work. So Paradigm Initiative, I've done a couple of work for them, from research to white papers and policies and all that. There are also litigations that are funded by these organizations, so Media Network, the African Academic Network on Internet Policy. I work with all of these organizations. Amazing, they're doing really amazing stuff. Even from an individual perspective, you see very interesting cases from Mr. Babalola, for example, just testing the requirements or the various sections of the Nigerian Data Protection Act. So when it comes to raising awareness, advocacy and lobbying, research and analysis, monitoring, accountability, empowering individuals, collaboration and partnerships, you see a lot of work from NGOs. It's really impressive, really.
That's amazing, because I'm not very aware, maybe it's my own personal problem, but I'm not very aware of these NGOs and the work that they're doing. So I think maybe at least for the benefit of everyone listening and for myself, if you could take out your time and just give us a name or some names that you're aware of so that we can also maybe be aware of them and if we can
No, I
volunteer
could.
as
I
well,
could.
yes, so
Now or
that we are all
later, I'm
passionate,
happy
I'm
to.
sure. Yeah, so it'll be worth us being part of what's happening. So let's know what's happening and be part of it. Let's make changes when we can. Thank you for that support and answer. So just moving on very quickly. I know Ilya mentioned about consent, and as well Tayo spoke about this. So when we have complex data privacy policies from different organizations, and of course we then ask people to give their consent, not that consent is terrible, it's good, it's a lovely lawful basis to rely on, but the question is, how much understanding does the person giving their consent actually have before they give you that consent? So I want to ask Wenga, I know you're on the call, so I just want to ask, in terms of consent, can we really say that our customers are really giving genuine consent? And when I say genuine, it means that they actually understand what they're consenting to, since our policies can come across as, verbose or, I don't know, opaque, it's not clear, it's ambiguous, a lot of legal terms that people don't even understand. Can we really say that they are giving good consent, that they're giving well-informed consent, just like the legislation says?
It's a very, very good question, and thanks to the prior speakers, providing answers. I think when it comes to consent, the ability of the data subject giving good consent is a function of what is the company actually doing in terms of asking the consent, right? So if you look at most laws, most privacy laws, the state requirement that you must meet, as a company when you seek consent from people, right? For example, if you look at the GDPR and even the NDPA in Nigeria, you realize that there are conditions for consent, the way you must ask for it. You can't couple it with some other things, right? You must separate it. The language you use must be very clear. It must be very direct, specific, right, to a particular thing. So if a company actually follow all of these requirements and you ask the consent properly, then it behooves the data subject to say, okay, I'm giving my consent or not. I don't think the data subject should be the one to be challenged when it comes to consent. I think people will give their consent really if they actually know what they're giving their consent to. What we've seen in practice, contrarily, is companies using, it's very, I don't know the right word to use, but I'm sure you guys understand what I mean. Ways to procure the consent, not in a very clear manner. They merge everything together. They're not so clear on what the consent is for. And because, again, it goes back to the power asymmetry, right? Because as a data subject, you want to have access to that service, you want access to that goods. You don't really care. Okay, cool. I'm just going to give my consent and just move ahead. So I think that's the main problem. I think most people give their consent if they know what they're giving consent for. But the main problem is how the companies themselves present the consent. Hopefully, organizations, NGOs, and the relevant supervisory authorities can actually take these issues up with organizations that present fraudulent consents to people. I think that's the main issue, really. I think it's just the way companies present the consent. They don't present good consent to people. The language is always very, very fraudulent. And because, data subject, you don't have a lot of options. You just accept it and just move ahead. That's the summary for my perspective, really.
Thank you. Philip, I saw your hand go up. I don't know if you wanted to add something or, yeah.
So many times when we talk about information asymmetry or when we talk about power imbalance, we tend to over-focus on consent as a legal basis, forgetting that there are other legal bases that also come in play and that would also sort of attain the same outcome in terms of not allowing the data subject a lot of flexibility. So I just wanted to point out that yes, we are discussing about consent and whether data subjects can validly give consent in Africa. Of course, because of the convoluted privacy notices we have out here, we have a privacy notice amounting to about 300-400 pages, you know, and then you need a service urgently, then you quickly sign off on it. But essentially, when you look at especially the most or the heavily worded privacy notices, tend not to mainly rely on consent as a legal basis. And therefore, much as the data subject would be signing off and would assume they are giving consent, when the rubber hits the road and now there's a claim or there is a complaint to a data protection authority, then you would realize that defenses would be something like, it was in our legitimate interest to process this kind of data, and we were just asking for your consent as courtesy. However, should you have not wanted the service, then you should have not reached out to us and such things. So consent really comes into play, especially when you're talking about things that require absolute consent, that is cross-border transfer of data, at least from the laws that I've read. We also have commercial use of data, at least in the Kenyan context, that is expressly given that you need to seek consent. But when we just discuss this topic within the larger context of data processing, then we also need to look at is the institution or is the organization or is the data controller really using consent as the main legal basis, or are they using consent as a sub-legal basis? And then that informs us to further interrogate whether now should there be a claim, or what really are they using to, you know, what will they use, to defend themselves should there be any issue arising out of that. So I feel like consent is always just thrown in there because you see you're going through a terms and conditions sheet and you're signing off on it and you're assuming you're giving consent, but they're not expressly asking for it, and then you'll say you didn't give consent to this, then they'll now throw in some other legal basis.
Very spot on. Thank you. Thank you. Before I go ahead, Christina, yes, I see your hand is up. So go ahead. Go ahead.
Thanks, Jennifer. Yeah, I just wanted to build on everything that's said, particularly Philip's point around remembering. It's a useful reminder, consent is only one of a number of lawful bases for processing. And cynically, I see consent as a bit of a smokescreen for organisations, and it goes back to the point around the lack of transparency. I work with a couple of marketing teams who are very clever in the way that on the face of it, it may look as though, as far as the individual data subject is concerned, it may look as though they've given consent to their data processing because of the behind the scenes technical machinery that the marketing teams have deployed. But in reality, the individual data subject has not given consent. So I'm nervous. I'm always nervous when organisations rely on consent. I think it's a bit of a smokescreen, and there are too many workarounds for organisations to say that they've relied on consent when in reality they haven't, or the consent is not truly lawful or GDPR compliant.
Exactly. That's exactly the point. And especially with the idea that, to be fair, if you don't give the consent, if you don't say yes, you can't use the service. So I'm caught in the fact that, well, technically that's not consent then, because if I don't say yes, I can't say no. So if I want it, I must say yes. So I'm not sure how that is consent anymore, you know, if you're making it like a take it or leave it situation, which is what we find for a lot of the services that we want to be part of, because you just can't say no. And so I wonder if there's anything that, you know, the regulators can do with this, because you're very correct. You know, we use, not me, they use, organizations use a lot of big words and just, yeah, it's more like if you really want to have this service, if you want to have this app, if you want to bank with us, you just have to say yes to these things, you know, and there has to be another way that they can rely on to do these things. And like you say, consent is just one of 6 lawful basis. We tend to ignore the other 5. I don't know. I feel like the other 5 is like, oh yeah, they're just there as extras, but they really are good lawful basis you can actually use, especially if you know why you're processing what you're processing and the need for you to do it. You can actually rely on other lawful bases. And I'm just going to mention them for the sake of this conversation. So we've got public task. We've got what was it called? Vital interest. We've got legal obligation. We've got contract and legitimate interest. So you have 5 more that you can consider. And if you don't know what these 5 are, feel free to reach out to any one of us. I'm sure we can explain. We'll be happy to explain. Okay. So just moving on from this in this conversation. So in terms of this transparency we've talked about, so is there any way in your thinking, based on what you've seen and heard, is there any way for us to, for example, tailor consent to fit individuals and their circumstances, because we're talking about the model by which we give consent now, and we're saying, well, it's not helpful. It's not really helpful. So the question now is there a way for us to, what will I say, to make consent unique to you as a user? Is there a way for us to make that so? Is it achievable, or is it just something we think that is theoretical, but I don't think it's very practical? So let me go to Tayo. What do you think?
Yes, I would say indeed there is. And we may have to refer to privacy laws to maybe get insights on how to approach this. So there are domain-specific privacy laws, there are regional laws, there are local laws on privacy. If you look at COPPA, for example, the Children Online Privacy Protection Act is an American-specific law, right? It dictates how you obtain consent from children, how you use the information of children. You can't do so without getting maybe written consent or the authorization of their parents or guardians. And also there's an equivalent law in the GDPR, actually, that for children above a certain or below a certain age, you cannot get their consent, right? And that's how you can only get consent from their parents. So in that way, you have a framework for getting consent from a particular group, and in this case, children. If you look at the HIPAA, the Health Insurance Portability and Accountability Act, also in the US, regulates the consent management framework for data subjects in the health context. So if you want to get an idea of how to tailor consent, how to obtain, how to manage, how to document, and accountability, sometimes you may have to refer to written laws, to written privacy laws. But beyond this, from a technical perspective too, and I think maybe this even overlaps with a different, I would say, theme or topic that we'll discuss. Also, from the point of collection, right? Technically, you can also implement some features that aid the provision of consent. It just helps. It makes it easier, right? If it is well tailored, if you're using icons that are very prominent, for people with eye conditions or something, for vulnerable people, they may be able to, easily, latch onto that, and it just helps. So I would say, from a technical perspective, there are options. And again, from a legal perspective, you can always look at specific laws or specific provisions in different laws to guide you on how to obtain consent from specific demographics.
Thank you. And just to ask, do you know of anyone or any organization doing this? I haven't seen, so I'm just wondering.
Well, it's not every organization that is subject to these laws has to comply with the requirements of the law, right? If I operate in the US, I'm subject to the provisions of COPPA, which is a law that's specific to children. It means that if I'm offering an online service, maybe games, for example, that, you see children are usually will be the biggest patrons of this service. I cannot directly collect consent from them. The consent has to come from their parents, has to come from their guardians. In such a way, the law has tailored the consent management framework for those sets of children or that particular demographic. So it's a function of law, right? If as an organization I'm subject to the law, I have to look at what the law says on how to design my consent framework. If I'm based in the EU, I'm subject to the GDPR. If I want to design consent, if I want to collect consent, I have to look at what the GDPR says. So it's more of a function of the law. It's not, I don't have much luxury. I have to look at what the law says in my region and comply.
So just to buttress what I'm trying to say, especially with the children's stuff, right? So, because my point is, there's no way for me, or at least currently, to the best of my knowledge, to know that the person who is giving consent is actually the person who I want them to give the consent. So when it comes to kids, for example, it's just an app, right? And you download it and say, oh, parents give consent, I'm over 18. Well, how do you know that it's not the child that gave the consent? That it's not.
Yeah, so there are some websites or some services that if you use today, they will give you options. Are you 18 years or younger, or are you 18 years or older? This is one feature. And also, one mechanism that we use would be independent oversight or even audits, right? Occasionally, you have to test your consent management framework to see that the age that the patrons or the people that are downloading your services or downloading your apps, using your services or downloading your apps, the age that they're providing is compliant. And also you can technically configure your systems, configure your apps to not provide that service if they provide an age that is lower than the required. So you can definitely adopt technical mechanisms. You can look at the law. You can also test with regular audits, ensure that you're looking at what you've set up, you're reviewing periodically. It could be every 6 months, it could be every year. But I would say from an operational perspective, the most effective would be to implement something technical, such that if I put something that says that my age is 13 or 14 and the minimum age is 18, then yeah, I won't access that service.
Okay, well, thank you for sharing that. Thank you for sharing that view. So let's just move away briefly from consent and talk about one of the rights that we have under data protection. So, I mean, it's a right that is based off of consent, by the way. It's the data portability right. So basically, with data portability, it means you can request the controller to send your information to another third party of your choosing in a format of your choosing as well. So the question now is, if we start to enforce data portability a bit more, because I find in my experience, not a lot of people actually use that right. I think it's barely really used by people. So the question is, if we start to enforce that right, or if we get customers to use that right a bit more, will that make data controllers a bit wary and reduce the sort of power that they might currently have? Well, because they are dominant, or because they are popular, and because people must use you. So you feel like you're untouchable. But if we have that option, that the data that I give you that is based on consent, that I can ask you to give it to someone else, will that make controllers a bit more wary and a bit more mindful, and more or less reduce the power that they have currently? So I saw Philip some moments ago. I don't know if he is still here. So Philip, if you want to take this question. Okay. Looks like he's not. It looks like he's not here now. So okay. So I'm going to ask Christina. You're smiling, so I'm going to ask you. I'm going to ask you the question.
Hi, yeah, no problem. Happy to contribute my 2 pence worth. I think it's an interesting angle to sort of ask the question, or hope that individual data subjects' awareness of their rights, particularly the data portability right, will lead to, I don't know, nervousness maybe amongst the data controllers in a way that stimulates competition. That is, do you know what? Philip is waiting to get into the lobby, or he's in the lobby. I think I've just admitted him. I don't know how I've got the admin rights, but I've just admitted Philip. So I think he's with us now. But yeah, where was I going with this? Yeah, so I think it's an interesting idea that data portability, or more people being aware of that right and then exercising that right, that whole scenario leading to data controllers feeling a little bit nervous and more aware of competition, and then waking up to potentially changing their game with regards to transparency, demonstrating more transparency with their data processing practices. I personally and professionally think that litigation risk is what will make data controllers wake up or shake them up to transparency. So when they see and are aware, particularly in the AI world, where data is being used to power the AI world, and then what that triggers in terms of litigation risk, I think organizations will be nervous about the risk of abusing data in the AI world, because the risk of litigation is much higher in the AI world. And I say that because it is easier to, on the face of it, and I realize I'm oversimplifying it, but on the face of it, it's actually relatively easier to pursue litigation around abuse of data in the AI world, because you can rely on lots of different legislation, not just GDPR or global data protection legislation. So many other pieces of legislation come into play when we talk about the abuse of data and litigation risk in the AI world. So that is, I think data portability is a useful angle in terms of, you know, the extent to which that might make data controllers wake up and be more transparent around their data processing activities. But I think litigation risk is more likely to shake up data controllers with regards to concerns around competition and the pressure to be much more transparent.
So more or less more enforcement, really, you know, more enforcement.
Yeah.
Okay.
Yeah.
Tayo, yeah, your hand is up. You're muted.
Yeah, I'd just like to highlight that this right, the right of portability, data portability is not absolute. The law says that it can only be exercised where it is technically feasible. So if the organization, if the entity is not capable, not technically able to implement your whatever request that you have, right? You may not exactly, you may not exactly be able to enjoy that right. And from my experience, right? I mean, let's make this very, very practical. Clear use cases for data portability would be maybe when you get a new SIM card, you want to move from MTN to Glo. That's data portability in a sense. But there are other use cases like that, right? But there are a lot of challenges that can stop, I would say, entities or data controllers from actually implementing the scalability issues. If the volume of the request is too much, they may not be able to. There's interoperability too, which is a very major problem. You know, if I have a system that I cannot integrate with the system of the competitor, I cannot process the request, right? But the truth is that indeed, I think to a very large extent, it does help reduce reliance on big platforms, and it helps them sit up, because of course there's competition. If I know that my consumers or my data subjects can easily move to a different entity if I don't process their request, I will, as much as I can, try to implement measures that will make it possible. So in that sense, I, as a user, if I know that when one party is treating me wrongly, I can easily move my data to another without incurring costs. It helps me, given some element of control as well. It does. And also, I would say one of the things that also, puts some form of pressure on data controllers in this sense is competition, right? You know that your users can easily move around. You know that you can suffer commercial loss, right? In that sense, it kind of reduces how much control you exert over the data of your consumers, of data subjects, and it shifts control to them.
Thank you. Yes, I do think you're correct. And even though we have some challenges with this specific right, but I think it's a right that we should welcome, really, for organizations to do more in, have this idea, because it sounds like an idea of an open, what will I call it? Open source. I don't know if that's the right term for those who are really in the industry, but just really that free flow of information from point A to point B, just having that free flow of data, it will come a long way, even though we know we have some challenges, specific industries or companies who might not be able to do it. But I think it will come a long way, actually, for us to do this. And I just want to touch briefly on AI, because I can see the time is running out quickly. Because Christina, you mentioned AI, and it's interesting, and we should really talk about this. So in terms of artificial intelligence and using it, one of the issues we have, because it's great, but the problem we have with it is the issues that can result from it. So first of all, you require a lot of data in order to use your machine learning programs and all of those things. And when you then have this data, one of the issues that can arise from it is the biases that it comes with. And, basically treating more people fairly than others, or discriminating against certain people. So what can we do, whilst we want to make changes to reduce imbalance, You know, if we start to use AI tools that would more or less keep more people at a disadvantage, what things can we then put in place to ensure that we don't disadvantage certain groups of people, you know, or marginalize them based on their characteristics, no matter what that may be? So I don't know, Philip, you're back on the call, so I can address this question to you again, if you can hear me.
Yes, I can. Yes, I can.
Lovely.
So, yep. Can you hear me?
Yes, we can. Yes.
Yep. So I think when we talk about AI and how the models are meant to use, I think there's someone who's unmuted and it's noisy. When you talk about AI and the models that are used to train AI and them being heavily dependent on data, then of course the big question comes that how have these models over time learned of this data? Of course, when you talk also about bias, this bias has been fed in by a natural human being, because these machines or these models don't necessarily come up with their own biases. These are biases that have definitely been fed in by people who have fed certain parameters into these systems. And therefore, with data protection from that point of view, it would also be one of those things.
Oh, it looks like we lost Philip again. So maybe when he returns, he can finish up on what he was trying to say. We just lost Philip there. Okay, so I'm just going to skip that question and I'll let him come back to it. But one of the things that I've read about that I'm going to talk about, so we have been seeing, you know, proposals about personal data stores. And basically what that means is, as a data subject, you are able to have your data in one, let's just say, an application or a wallet. And then you are able to then give access to controllers by yourself, you know, in the way and manner you wish. So if you wanted to withdraw your consent, you know, you can give them like a view only access. And if you're tired of them having your data, you can just yank it off of them, you know. I mean, I've not really seen this play out yet, but I've heard that it's a proposal of something that could be in the works or that could help us to bridge the imbalance gap. So let's think about that question, because Philip is back, so I'm going to bring him up again to speak. But let's think about that question and who will take it. I think Wenga, you're still on the call. So Wenga, you take that after Philip is done. Philip, please go ahead. You're muted, Philip, if you're speaking. We can't hear you. Philip, you're muted.
Yeah, I was saying I didn't have the permission to unmute myself from my end. Yep, sorry, I keep dropping off. I think it's a network issue. But anyway, as I was answering, is that individuals can challenge algorithmic decisions, and especially you look at the right to against decisions based on automated decision making that is present in very many data protection laws. And one of the things that need to be made very clear at the very first instance is that when you're interacting with a certain system, is that this system is utilizing is making an algorithmic decision based on automated decision making, and therefore should you not be satisfied with the outcome of a certain decision, you're able to, of course, reach out and also request for a human being to intervene. And this is very popular when you look at the employment industry, where for jobs that are advertised, especially on a global scale, you'll find that many times they use what we call an ATS, an application tracking system, that passes through all these CVs that are shared and then makes a decision or an algorithmic decision based on what parameters have been set on the back end by a human being. So at times when individuals are not satisfied, it is always very hard for them to maybe raise this out, maybe raise this up with the concerned party, especially because, again, of what we've been talking about, the information asymmetry. Number two, not many of these people give reachable contacts that an individual may be able to reach and challenge these decisions in when and as they are made.
Thank you. Thank you for voicing that out as well. That is true. We do need some ethical considerations. We have to have some rules. We have to have, I don't know, some level of framework that we all can agree to follow when we are using AI. And I think a lot of countries are coming up with them. I mean, in the EU, I know that we have the Data Act that is out. And I mean, the whole point is so that everybody has a level playing field. If you're going to use AI, you have the same instructions, so the government has thought about it. Like they think, okay, this is going to work for people. And of course, we can try to abide by those requirements. And hopefully, it will keep our data subjects safe and it will not really unfairly disadvantage anyone. So, Wenga, just coming back to you on that final question, I should call it at this time because it's 1 o'clock now. That final question about personal data stores. So it's just an idea that I've heard about that has been proposed. And I mean, it could be a thing. I don't know, but it's just worth asking if you think that is something that could help to also reduce the imbalance that we're talking about.
Definitely. And I've heard about it as well. The unfortunate thing, of course, is that we can't really speak about it as we don't know like the intricacies how it's actually going to play out. But I think personally it's a function of the Web 3.0 that we have right now. Web 1.0, users can go on a website and just access a static page. You can't really do anything. Then we move to Web 2.0, which is what we have right now. You can interact, and the business who owns the platform can also interact with you. So it's no more static page. But Web 2.0, the organization, the platform still are in control. But now we're moving to Web 3.0, which is what you just mentioned right now, is an example where you, as the data subject, is actually in control of the data. Now you have the wallet where your data is, and you can give organizations, access to that data, whichever way. Maybe you're going to give them your password or some token or whatever for them to have access to it. But the central thing, of course, is that as part of Web 3.0, you are in control of your data. You decide who have access to it. The only problem, perhaps, that I see, from a privacy perspective, is that doing that would also raise some privacy challenges, especially data minimization. So let's say you have, in your wallet, you have your name, your email address, your home address, your social security, or such numbers, and whatever information you have in that wallet. And this organization is trying to have access to what they actually perhaps really need is your name and your email address, and give them access to your wallet. Now they have access to like all of this information that they don't even need. So perhaps that's something that one of the challenges that users might want to like take into consideration when they give access to companies to have access to their wallet. But to answer your question specifically, like, is it something that is good that gives users some control? Yeah, I think it's one of those things that gives you control. But then we have to be very careful as well. But like I said, we don't really know the complexities and the intricacies of how it's going to work for now. But from just the theoretical perspective of how it's going to work, I think it gives you some kind of control as a data subject.
Thank you.
So
Thank you.
if I want to make a very quick addition to that, I think one of the beauties of this concept is that data minimization might actually not be much of a concern, because that's the whole point. When you have a user managed data wallet or even a personal data store, you're able to control what information goes to third parties. You can make that determination. You can give access. You can deprovision access. And there is an audit trail. So anything that leaves, you know what is leaving, and you know what it's being done with, and you can stop access at any time. So that's one of the, I would say, one of the advantages that we will be getting from this concept when it becomes like really live and commercial. But one reservation that I have is also awareness to, like, how many people understand what Web3, right? I mean, the very simple tools that we have, like regular cloud drives, like, what's it called, Dropbox and co. There are very few people with knowledge Not a lot of people know how to operate these things. So if we make it a little bit more technical, I'm wary that we may also be cutting off some demographics, some like vulnerable people, for example, or children or people without much education. So awareness is one thing, one concern. But when it comes to overall usage, I think this is a fantastic concept, right? And one of the selling points would be the kind of privacy and security assurances that you will be getting from it. And more importantly for me is the audit trail. You know what is going where. You know who is using what when it comes to your data.
Yeah, I couldn't agree more. Philip, I saw your hand up, so let's get your views before we wrap this up.
Yeah, maybe just to also add on that topic, I think also going that way would sort of make controllers relinquish their responsibility with respect to data protection to the data subjects, to the extent that if there's any breach or if there's any mismanagement of personal data, then all the data controllers would need to say is that we do not have absolute control of your
Looks like we've lost Philip again. The network situation in Kenya. What can we do about it? Oh my days. But I believe what he's trying to say is if this does work out, it just means that there will be less for controllers to actually do, and there will be more responsibility placed on data subject. And so, I mean, yeah, truly, if there's a data breach, for instance, I mean, the controller will still be at fault, but then it will be easier for the data subject to know exactly where it came from, and to be able to say, well, I have the evidence, this happened. And so you can't chicken out of it. And of course, I also agree with your point, Hayo, about the awareness, because, I mean, we don't even know, we're not very knowledgeable of the law on its own now, not to talk of when we have more tools that would help us to manage these things by our own selves. Yeah, so it's a wonderful concept. I do agree. I think I like the idea of it, but let's wait and see, like Benga did say, what it would mean, what it would entail, and how it would actually function. So I'm conscious we're out of time. So just to wrap this all up, so if every one of us who are speakers here can just give one final advice. So I will give you the people you're giving the advice to. So to us, regular people who are the data subjects, any word of advice, and then to the enforcers who would obviously take this on and do something about it, and also to organizations who are processing data, and let's see who else, and maybe to DPOs as well. So feel free to pick one of the four and just give one final piece of advice when it comes to power imbalance.
I can go first if that's okay. And of course, my advice would be to users, right? So unfortunately, there's very little we can do when it comes to our situation or our relationship with big techs. Because of the power, the dynamics, there will always be that imbalance. I mean, I don't have enough money. I cannot compete with Facebook, with Meta. I really do not have a comprehensive insight into what they do. But irrespective of that, we should have it at the back of our minds that there's a lot of work that's being done by regulators to help us. These laws exist for us as users, and we should try to leverage them as much as we can. The idea is that if we don't leverage these laws, it would be like a free-for-all when it comes to how these organizations use data. They won't really respect them. But because these laws are there, these laws are being enforced, the only way that we can add to that is to leverage them. And how do we leverage them? By educating ourselves. So as much as we can, let's read up on the rights that we have. Right? A lot of people still don't know what data subject rights are. A lot of people don't know that they can approach organizations and ask them to delete their data, for example, or ask them to correct whatever data they have in their databases on them. So the more aware we get ourselves, the more we educate ourselves, the better we can leverage these rights and protect ourselves. And again, for me, the ultimate aim of data protection, in my opinion, is control. I'm not sure that I really care what these organizations are doing with my data per se. I do care. But more importantly, I want to be able to say what they can or cannot do with my data. That is the most important thing. I mean, I want to use Facebook. I like you. I don't use Facebook, but I like to use Twitter. I like Instagram, right? So if they use my details to sign me in, to make me see the beautiful faces of my friends, it's nice, right? But I want to be able to say that this is what you should do with it. When I'm done with the account, I want to be able to say, you know what, delete my account. And the only way to do that is to know what these organizations are doing with the data or with whatever data they collect from me, and what rights avail to me within the laws or in the laws that exist, how I can leverage them. And all of these things are they're available on the internet. It will take less than 5 or 10 minutes to really educate yourself, at least the basics, the most important thing to educate yourself. And also test them, test these rights.
Yes,
Test them
I
as much as
agree.
you can.
Test it.
Sometimes it
Test
could be
your
a simple
rights.
email and you'll be surprised because these laws they're not optional. Organizations do have they have an obligation to respond to them, to deal with them within specific timelines. So if you tell an organization, please delete my data, for most of them, especially in most of the countries, the regions, they work with a 30-day timeline, right? They have an obligation to delete that data in 30 days. Very quickly, let me say this. There's something that I do. So I do privacy in the employment context. It's almost exclusively at this point. It's very niche, but it's very interesting, right? When you apply for jobs, this is an industry secret. When you apply for jobs, for example, you get a rejection email. So people just leave it at that. If you ask the organization and say, hey, why did you reject me? Nobody will give you a response. But if you
But
actually
you can
want to
put in
know
a sum.
why you were rejected, there are other ways to do it. You can ask for copies of your information or copies of the interview notes. And they have an obligation to give you copies of the interview notes, right? If you're not aware of these things, there's so much that you will be missing out on. So I'll just leave it at that. Education is very important.
Yes, thank you. And just to buttress on this point, I really, really agree. If everyone here on this call, wherever you're located, go and send an email to whatever organization you know that has your data. Just test to see whether they actually know what you're talking about. And if they don't respond to you, you can more or less report them to your enforcement agency. Let them pick it up. Let them know that these people are not doing what they said they should do. And of course, on that point about interview notes, it is true. It's industry chic. People don't talk about it a lot, but it's true. If you want to know how your assessment went, if you want to know why you failed, or I don't know what the interviewer thought about you in your interview, you can actually make a SAR to your organization that you applied to.
Don't ask for why you were rejected. Ask to see a
don't
copy
ask for
of the
that.
interview
Ask
notes.
specifically, yes. Ask for the copy of your interview notes because they can give you that. They can definitely give you that. Even let me see, can they give you answers to the questions you asked? Not the questions of the exam. I think they can give you copies of the answers that you gave. Because that's your own answer, it's your data, so you can have that. So yes, please go ahead and do that if you want to know more about your interviews and why you're not maybe getting it. So you can definitely do that. Okay, Christina, yes, you can go ahead. One final advice.
Great, thank you. Yeah, my quick advice would be to professionals in the space. I think we need to and kind of building on Teo's point around the legislative landscape. As professionals, we need to definitely upskill ourselves and be much more aware of the broad legislative landscape that governs data use for organizations, because as the data legislative landscape becomes more complex and multi-layered, that all of that is shifting more power to individuals in terms of them being able to empowering them to litigate. So my advice to professionals would be make sure that you are aware of the broad data and tech regulatory and legislative landscape that impacts and governs data use, because the legislation around data use goes way beyond now data protection and GDPR. We've got the AI Act and other pieces of legislation. So that would be my one advice to professionals working in this data governance, privacy, professional management space. Understand the data and tech landscape. It goes beyond the AI Act, GDPR, and data protection legislation.
Thank you. That is true. There's more coming up actually, and we need to be aware. I think there are organizations that actually, publish newsletters to keep us up to date of what's happening across the world as well. So it's good to be up to date. You can subscribe to the newsletters from these organizations, and you can get, you can just know what's happening so that you'll be aware when you start projects with these people that might work in other jurisdictions. It's good for you to know what your requirements are because of the kind of laws that they have there. So thank you, Christina. That was very helpful. Wenga, yes, go ahead.
Yeah, of course. So I think I would try to give advice to, I know none of us is a company, but perhaps we represent a company. You know, we can give advices to data subjects, you know, how they should be proactive about their privacy in the digital space. We can give advices to privacy professionals, but I think at the end of the day, the ball stops with the organization themselves. So if any of us is actually representing a company, three things I want to mention to companies as they process people's data, right? So one, I think companies should take steps to respect privacy choices of data subject, right? It's one thing to give data subject the privacy choices and things they can select, right? Things that they want, you know, in terms of the data processing. It's another thing entirely to actually respect it, right? So I think companies should take steps to actually respect. If someone says, I don't want to be tracked, or I'm rejecting these cookies, don't still go ahead and place the cookies, bro. Just leave it at that, right? So that's one. Two, people exercise their right, right? Like Tyler mentioned the other time, people have the, you know, most privacy laws that give people the power to exercise certain right, to have access to the data, to ask for deletion, to transfer it to someone or to any other organization, right? As companies, there's no point playing tactics with people's data subject rights. And someone said they want access to the data, just give them access to the data. Like there's no point, you know, wasting time or trying to like redact the information if there's no need to do that, of course. So respect people's data subject right. And I think the last thing I would say to companies, and I think most of us can take back to our various organizations, is to also build privacy by design principles into our product, right? If you have a product as a company, or you have a business process, whatever you have, you know, that entails the processing of data of people, try and incorporate privacy by design into it. You know, and that of course means being proactive with people's right, privacy right and choices, privacy by default, and the rest of it. So those are my three suggestions for companies, for data controllers, for the most part.
Thank you.
Of course.
Thank you. No, go ahead. Sorry, go ahead. Oh, okay, you're done. Thank
No,
you, really,
that's it.
Wenga. Honestly, yes, thank you. That was very brilliant. And my own personal advice to organizations, especially when it comes to handling rights, hire more data protection staff members, because that's the excuse I find. We just don't have the capacity to deal with this. Well, maybe hire people to actually deal with it then, because why not? You know, we have people with their request, and we need to be able to handle this request in good time. So if that's the case and you know that you have the obligations, then please hire more hands, train your staff members, let people be aware of what their obligations are, and really actually try to fulfill it. Thank you. Finally, we have Philip. Hopefully you can hear me. Is this thing there? Can you hear me? Yeah. Okay.
Yes, I can hear you, but
final advice.
yeah.
Yes.
Yeah, I won't turn on my camera. I think I've
Maybe
experienced the
it's
worst.
okay.
Yeah, the worst network today. Yeah. So my parting shot would be for companies, as you've said, I think they need to rethink their data protection, one, budgets, and number two, their data protection approach, because especially from the context, the African context, many organizations have not yet grasped the importance of data protection, and therefore the budgets you keep hearing that have been put in place to handle data protection matters are budgets that would be considered as petty cash, if I may say, for other organizations out there. And therefore, it is very important that one, budgets are put in place, and that two, we also begin to appreciate the need for fractional data protection officer services. Again, I speak from a Pan-African point of view. In the UK, in the EU, may have been there since 2018, with the GDPR, of course, way earlier with other privacy laws, but the GDPR coming into place in 2018. And Africa, relatively new, the authorities are still trying to figure out ways in order to ensure compliance, and therefore controllers are not really invested in privacy because they're asking themselves, what is the worst that can happen? And so that approach is very skewed because they're approaching it from, will we be punished? Should we not comply? If there's no imminent punishment, then they're not really concerned about that. Thirdly, I also think that data protection authorities have a very important role to play in this ecosystem, in the sense that they should not only make this quote unquote a money-making enterprise, where for licensing, for administrative fines, for very small things, you keep either putting in a fine, damages, or what have you. I think the authorities would play a very key role in sensitizing the controllers and processors on, one, the importance of compliance, not just from a penalty point of view, but the importance and how it fits in back to the whole issue on the rights of the individual and the right to privacy. So I'd approach it in those three specific areas. Thank you.
Thank you so much. Thank you so much, everyone, for your contributions. It has been absolutely amazing having this conversation with everyone here, with all of our panelists. I don't see any questions in the Q&A, and I'm very conscious of the time. So this is me assuming that no one has any questions. But if you have any questions, if you put it in the chat, I'm sure we can take it away and maybe try and respond to you personally. So again, thank you everyone for joining. Thank you, Wenga. Thank you, Tayo. Thank you, Philip. Thank you, Christina. Thank you, Ilya, who is unfortunately absent now. And thank you, Victoria, as well, who also couldn't make it. I hope I didn't miss out any names. Thank you all again for attending, and we really appreciate your time in this conversation and obviously sharing your insight and your knowledge. I'm sure that everyone who attended has had something to go home with, something to think about, and maybe even an action to take as well. So we really appreciate your time for being here with us, and we look forward to seeing you again soon. I'm sure we have more interesting conversations lined up in the future, and this is your invite to be back to join us for any of our conversations. So once again, thank you. Thank you, everybody, for participating. And I hope you have a good afternoon.
Thanks, Jennifer.
Thank
Bye,
you.
everyone.
Thank you. Bye, everyone.
Thank you, Jennifer. Thanks, everyone.